If you're buying a home in Florida in 2026, this is something you need to understand immediately. You're not just shopping for property. You're signing a legally binding contract that can cost you thousands of dollars if structured incorrectly. And most buyers, even smart buyers, don't realize where the real risk is. I'm Arthur Simpson. I'm both a Florida real estate attorney and licensed realtor. That means I see both sides of the deal, the negotiation side and the legal enforcement side. Today, I'm walking you through 7 contract mistakes that cost Florida buyers serious money and how to avoid them. Earnest money is not symbolic. It is not a gesture. It is leverage and it's exposure. When you submit a contract, you're usually depositing anywhere from 1% to 3% of the purchase price. On a $600,000 home, that's $6,000 to $18,000 sitting in escrow. Most buyers assume they can get that back if something goes wrong. That's not automatically true. If you miss a deadline, inspection period, financing notice, written cancellation requirements, you can lose your deposit, and the contract will not protect you from poor calendar management. Here's the strategy. Before you sign anything, you should know every legal contingency deadline in writing. You should calendar them, and you should understand exactly what written notice is required to protect your deposit. Contracts are not emotional, they are mechanical, and missed mechanics cost money. Now let's talk about the inspection period. This is where most buyers think they have control, but most buyers misuse it. The inspection period is not about making a punch list, it's about leverage. I see buyers make 3 major mistakes. Number 1, they overreach on cosmetic repairs. Number 2, they send emotional repair requests. And number 3, they fail to understand the economics of credits versus repairs. When you ask for everything, sellers get defensive. When you negotiate strategically, sellers get cooperative. Here's what I advise. Focus on structural issues, major systems, safety concerns, and financial impact items. If a roof has 5 years left, that's leverage. If an HVAC is aging, that's leverage. If it's chipped paint on a baseboard, that's noise. And here's the bigger mistake. Buyers asking for repairs instead of credits. Credits give you control. Repairs give the seller control. That difference alone can save you thousands. Next, appraisal gap clauses. This one is extremely dangerous if misunderstood. If you agree to cover an appraisal gap, you're agreeing to bring cash above appraised value if the bank says the property is worth less than the purchase price. Let's say you agree to buy at $650,000. The appraisal comes in at $620,000. If you signed a clause agreeing to cover the gap, you may be required to bring $30,000 extra to closing in cash. That's not theoretical, that happens. Before agreeing to any appraisal gap, you need to ask, can I afford this? Is the property truly worth it? And how competitive is the situation? Winning is not about paying the most. It's about structuring the cleanest risk-adjusted offer. Pre-approval letter is not final loan approval. It's the beginning of underwriting, not the end. Financing collapses late in transactions because debt ratios change, employment shifts, credit gets pulled again, large purchases are made during escrow. And here's where buyers get hurt. If your financing contingency expires before you formally cancel, your deposit can be at risk. You need to know, when does the financing contingency expire? What notice is required to extend or cancel? And are you still protected if underwriting delays occur? Hope is not a strategy, deadlines are. In Florida, insurance is not optional and it's not cheap. HOA fees, special assessments, and insurance premiums can change the economics of a deal dramatically. Buyers focus on purchase price. Smart buyers focus on total cost of ownership. You should review HOA budgets, upcoming assessments, master insurance policies, flood zones, wind mitigation factors. If you wait until the week of closing to discover a $10,000 assessment, you are negotiating from weakness. Title problems are more common than most buyers realize. Open permits, unreleased liens, boundary disputes, code violations. If these are not discovered early, they can delay or derail closing. The closing table is not where you solve problems. It is where preparation is finalized. Make sure title is reviewed thoroughly and early, not just assumed. The final mistake is weak offer structure. Messy contracts lose. Unclear timelines lose. Poorly written addenda lose, even at higher price points. When sellers see clean structure, limited ambiguity, organized timelines, they feel confident. And confident sellers choose those offers. I win offers not by increasing chaos, but by reducing seller anxiety. Structure wins. If you're buying a home in Florida in 2026, understand this. The contract is where money is won or lost. Not at closing, not at inspection, at structure. If you want your offer reviewed or structured with legal precision, not guesswork, there's a link below for a Florida buyer's strategy session. I'll walk you through your risk, your leverage, and your protection plan. I'm Arthur Simpson. List with a lawyer, close with confidence.